So we've talked a little bit about AI in this conference, and I thought because it's our last day and because these two gentlemen are so well known, Dean Erwin Chemerinsky and Paul Clement, that I would try something a little fun and different. So I went on to, and I won't say which name, one of the AI platforms, and I popped in their biographies, and I said, could you rewrite this in a different voice? And they did, or it did. And so that's what I'm going to start you with this morning. In the voice of Greek mythology, O wise judges and learned advocates, as we gather this early morn, into our midst strides Paul Clement, a champion foremost among mortals, whose exploits before the highest court rival the epic journeys of Odysseus before Olympus. From the storied towers of Georgetown and the hallowed libraries of Cambridge and the august halls of Harvard, he honed his intellect as Daedalus fashioned his wondrous art. Under the tutelage of sages Silbermann and Scalia, like young Achilles learning at the feet of Chiron, he was tempered for greatness. Ascending at last to serve as Solicitor General, he became as wise as Athena, guardian of law and shield-bearer of justice. With more than 100 contests upon the marble floors of the Supreme Court, he has crossed swords in matters of fate and freedom, his arguments ringing forth like Apollo's lyre. We welcome Paul Clement, whose presence today graces our panel and whose words may yet echo in the annals of our own epic discourse. And in Shakespearean voice, 'tis mine especial pleasure to present unto thee Dean Erwin Chemerinsky, a luminary amongst legal scholars and the esteemed steward of Berkeley Law, revered across this land for his profound wisdom in the laws constitutional, in the mysteries of federal courts, and in the sacred causes of civil liberties. He hath penned tomes and discourses many, over 200 by gracious count, enlightening both the bench and the bar alike. Not only through scholarship, but by eloquent argument before the highest court in the realm, doth he lend his voice for justice. Truly, he is a beacon to those who cherish learning and virtue in the law. Pray, let us welcome graciously Dean Erwin Chemerinsky. I tell my jurors I'm not very funny, and so I'm always stealing from someone else. So as we prepped for this meeting and panel this morning, what I want to share with you is that both Erwin and Paul really want to do a couple of things. One, they want to respond to questions that you might have, so feel free to start sending them up. But two, they wanted to try to figure out what else new to say, because much has been written on this topic. So because we have a dean of a law school, not surprisingly, he gave us some structure. And he put the discussion into 4 buckets. I'm going to preview those, and then I'll turn it over to our panelists. So just to preview, 1, is there really a threat to judicial independence? 2, why should we be concerned? 3, what can we do about it? And 4, how do we think about accountability for judges? So we'll begin with our esteemed dean to talk about this start of the discussion. Dean?
Thank you so much. Thank you for the incredibly kind introduction. Paul and I have both been introduced many times, but never like that before. It's also really wonderful to be here with Paul. There is no lawyer in the country who I admire and respect more than Paul Clement. On December 31st of 2024, Chief Justice John Roberts issued his State of the Judiciary report. He focused on judicial independence. He included eloquent quotes, starting with Alexander Hamilton and continuing through Chief Justice William Rehnquist. And he identified 4 threats to judicial independence. Now, when we look at the events of the last 6 months, this seems prescient. First, he talked about the violence and threats of violence against judges. He noted in the prior 5 years, the United States Marshals had found 1,000 credible death threats against judges. And as everyone in this room knows, they have been taken seriously. We know of the tragedy where Judge Esther Salas' son was killed. We know of the tragedy a number of years ago where federal Judge Joan Lefkoe's husband and mother were killed. We remember the tragic murder of 11th Circuit Judge Robert Vance. In 22 and in 23, state judges in Maryland and Wisconsin were killed. We know of the individual who traveled from California to Washington to try to kill Justice Brett Kavanaugh. And the threats to judges have only increased in recent months. Judges who have issued high-profile rulings, and I know many in this room, have been targeted with threats to themselves, to their family members. Just last week, D.C. Circuit Judge Michelle Childs said there have been 7 instances this year where pizzas were sent to her home, a way of trying to communicate that people know where she is and could come after her. A second thing that Chief Justice Roberts talked about was the intent to intimidate the judiciary. As soon as the first federal judge ruled against the Department of Government Efficiency, DOJ, Elon Musk took to social media and called for the impeachment of that judge. To right now, this year, impeachment resolutions have been introduced in the House of Representatives against 7 federal judges. There have been other efforts to try to intimidate the judiciary. As Paul will talk about, there's the action against the 6 federal judges in Maryland. There's the arrest of the federal judge in Wisconsin. There's the rhetoric that's been very much trying to intimidate judges. We all certainly agree that judicial decisions are subject to criticism, even harsh criticism. But a lot of the rhetoric has crossed the line. 2 weeks ago today, a federal judge in Los Angeles ruled that ICE could not stop individuals without reasonable suspicion, could not engage in racial profiling. The Secretary of the Department of Homeland Security, Kristi Noem, responded, quote, "He's an idiot," referring to the judge. Well, the judge was a woman, but beyond that, didn't we all learn in elementary school that we don't talk to each other that way? The Speaker of the House, Mike Johnson, said that as to courts that rule against the president, Congress could just eliminate those federal courts. Again, it all seems about an effort to intimidate the federal judges through the rhetoric, through the actual threats that are being made. Chief Justice Roberts identified a third set of actions that are being taken against federal judges, and this too is very troubling. Chief Justice Roberts talked about the way in which there's threats that judicial orders will be disobeyed. And again, there's real concern. What if the president chooses to disobey judicial orders? Everyone in this room knows that ultimately we rely on good faith compliance with judicial orders. You as judges have the contempt power, but if it's criminal contempt, there can be a pardon by the president. If it's civil contempt, it's ultimately enforced by the United States Marshals. What if there is a situation where there is a judicial order and it's disobeyed? In American history, it hasn't happened. I know many quote Andrew Jackson as saying, John Marshall made his ruling, let him enforce it. But Andrew Jackson never said that. It wasn't attributed to Andrew Jackson till 20 years after Andrew Jackson left the White House. We've heard, certainly from the president and vice president, suggestions that they might violate judicial orders. President Trump has said, quote, "He who saves the country violates no law." Vice President Vance has said that the president doesn't have to follow judicial orders if they intrude upon executive power. We can certainly talk about whether or not there's been non-compliance with judicial orders, but it is something that raises great concerns going forward. I would focus on these aspects of what Chief Justice Roberts has said as an indication that the threats to judicial independence are real, that they have to be taken seriously. As we talk about judicial independence, it's important to draw a distinction between decisional independence and institutional independence. Decisional independence is that each judge should decide every case based on his or her best view of the law or facts. We can talk about what things can undermine judicial independence. And then there's institutional independence, the actions of other branches of government that might undermine the ability of the federal courts to decide cases. These are actions of other branches of government that could interfere or usurp the powers of another branch of government. And I know over the course of this hour, we're talking about both threats to decisional independence and also threats to institutional independence.
So, Paul, can you tell us what's happening now, and including perhaps, let's say, the attacks on the law firms, going beyond just the judiciary?
Sure. No, thank you. And let me just say how delighted I am to be here and delighted to be here with Erwin. We've had the pleasure to talk about the Supreme Court term many a time, but today to speak with him on such an important topic is a real pleasure for me and a privilege for me. So maybe I'll just start by talking about a couple of the cases that I've been involved in, involving both sort of issues involving the judiciary as defendants and law firms as plaintiffs. So let me start with the judicial cases. I've been involved in a couple. I'm currently part of a pretty large and sophisticated team that's representing Judge Hannah Dugan in Wisconsin, and this is maybe just slightly different from some of the core threats to the independence of the federal judiciary, but this case sort of presents a little bit of a federalism overlay on this as well. As many of you probably know, sort of the underlying facts of this are both somewhat in dispute, but the broad outlines are that ICE agents decided that they wanted to arrest somebody who was essentially a defendant in a state court criminal proceeding and was making an appearance. And Judge Dugan kind of understood this, thought there were some sort of court protocols about how this would be handled, and ultimately sort of sent the defendant after the hearing out through one door rather than another, something that she's done on previous occasions. For this, she was arrested in sort of a dramatic fashion, and now the case is proceeding through sort of motion on sort of immunity, motion to dismiss the indictment, and could proceed to trial later this summer, depending on scheduling, of course. And that case, I think, raises some very interesting issues, both about judicial immunity and state judges, to the extent to which they have any judicial immunity. It's pretty well established they don't have immunity from a prosecution under the Reconstruction Amendment statutes like 18 U.S.C. 242. But I think the question of whether they can be treated in this way under sort of other statutes is an open one. And I also think the whole question of whether these statutes really reach this kind of situation. There's a lot of different ways to obstruct justice, and being a state court judge is not one of the most obvious ways to do it. So the second case I'll mention is a newer one. It directly involves the federal judiciary and raises, I think, some really critical issues of separation of powers and judicial independence ultimately. This is a case that arises out of the District of Maryland. As many of you may have seen, there are some cases that were brought there under habeas petitions where there's been controversial orders and the orders were not fully complied with, and there's been a clash of the executive and the judiciary in that context more generally. But the most recent action of the executive was a response to something that the district had done, which is to have a standing order that basically said they would give, essentially freeze things for 48 hours after a habeas petition was filed, and essentially have the executive branch not remove somebody from the jurisdiction during a 48-hour interval where there could be proceedings to figure out whether there was a basis to exercise jurisdiction and whether there was any basis for further judicial relief. And so that standing order of 48 hours, the executive branch challenged not by challenging it in an individual case, which I think would have been the normal and typical path to challenge that order. It's certainly not above challenge. But the executive branch decided that it would sue every judge in the district the District of Maryland itself as an entity, and the clerk of the court. And of course, once you sue every judge in a district, it creates certain recusal issues. And so in this case, the first thing that had to happen is that the Fourth Circuit had to get involved, and it designated a judge from the District of West Virginia to sit as a limited purpose judge of the District of Maryland. The second thing that happens when an entire judicial district is sued is they have to go out and retain private counsel, which has its own complexities, especially because private counsel typically have matters pending in that court. And so this is now going to be adjudicated. But as I say, the separation of powers issues, I think, that are raised in this case, I think it is, certainly we just filed a brief that if you're having trouble sleeping, I recommend you read the whole thing. But the gist of the brief is there are plenty of other ways to challenge this kind of standing order. This kind of direct suit against an entire judicial district is really unprecedented, and in our view has constitutional problems and other problems as well. And then just to complete the discussion, I'd want to make the bridge to the law firm cases. And I think it would be hard to miss that there was a series of executive orders directed at a handful of law firms, essentially taking action against them based on representations that they'd previously taken, based on who they had hired back to the firm after government service, and also in part and in fairness based on some of their affirmative action programs and things like that. But as to all of these executive orders, the basic form was to direct that these law firms be barred from government buildings, be barred from not only obtaining any government contracts, but anybody that had is a government contractor had to disclose to the executive branch the extent to which they had a representation from these law firms. These were quickly challenged by some law firms. Obviously, some other law firms decided to cut a deal, but at least 4 law firms quickly challenged these rulings, and in all 4 cases, they first obtained temporary restraining orders against them and have now gotten more permanent relief, and the government has recently signaled that it will appeal these decisions to the D.C. Circuit. Just the last thing, and maybe to draw a slight link between the law firm cases and some of these broader issues, I just thought I'd read, and so much in the separation of powers, but I think in some of the issues that Erwin highlighted, depends not just on exactly what the law is, but also the tone and the tone of communications, the way people criticize courts. I think everybody recognizes there are legitimate ways to criticize judicial decisions with which people disagree. I've done it myself. But at the same time, there are wrong ways to do it as well. And I also think that there are probably special responsibilities about the way that the political branches talk about judicial decisions they disagree with. Again, I think they're perfectly entitled to express their disagreement. But in the context of the law firm cases, when the first TROs were issued against the order, I'm just going to read the first paragraph of the official compliance memorandum. And it's quite extraordinary, from the Attorney General and the Director of OMB to all of the various federal agencies that were directed by the executive order to take action against the law firms. And when the TRO issued, this was how the Attorney General and OMB Director directed the rest of the executive branch to comply with the TRO. And it starts, quote, "On March 28, 2025, an unelected district court yet again invaded the policymaking and free speech prerogatives of the executive branch, including by requiring the Attorney General and the OMB Director to pen a letter to the head of every executive department and agency. Local district judges lack this authority, and the Supreme Court should swiftly constrain these judges' blatant overstepping of the judicial power." Now, they go on to say, comply. And I'll only say that this is particularly remarkable because although this compliance memo said that the Supreme Court should swiftly constrain these judges' blatant overstepping, the government didn't seek a stay, didn't seek the Supreme Court's intervention. So they just sort of put this in the compliance memo.
Let me then just ask, should we be concerned? I've heard some people say, look, this is a blip. We got through the 60s. You know, it's politics. We're going to get through this. No big deal.
Oh, I think we should be enormously concerned. I think we should be concerned in terms of the independence of the judiciary and what it means for our democracy. After all, it was Marbury versus Madison that said the Constitution is meaningless unless there's enforcement, and we need the courts to enforce it. We've seen in other countries undermining judicial independence is a path towards totalitarianism. I also think we have to be concerned at the human level about the judges and what they're being subjected to when it's death threats, threats to their family, a deluge of hate mail. If I can just talk personally for a moment, after an incident that occurred in my backyard a year and a half ago that went viral, my wife and I received dozens of death threats, thousands of computer-generated hate messages, many vehemently anti-Semitic. You can put on the filter so most don't get through. You can delete them, but still knowing they're there takes a psychological toll. So I think we have to find the way in which we're going to support the judges who are experiencing this. And it's nothing like the 1960s. In part, it's different, I think, because of the vitriol of social media, the quantity in terms of the number of judges being targeted and what they're suffering through. And also, this is different because it's the President of the United States and cabinet secretaries who are expressing and leading all of this. That didn't occur in the 1960s.
So maybe we move to thoughts about Congress's role. Paul, what are your thoughts about how Congress might have a role? And
So I think Congress does have a role, and one of the things that I think any student of the separation of powers will realize is that the independence of the judiciary depends a little bit on Congress taking certain actions. I mean, Congress pretty squarely has the power of the purse, and the federal judiciary requires funding to operate. And I think it would be a challenging argument to say that there's some sort of constitutional mandate for Congress to fund certain things. So
we're sitting here on the West Coast, right? You spend a lot of time in D.C. Articles of impeachment are getting filed. Is it just fluff? Is there really anything that's going to happen? Can you give us some sense of what it's like in the Beltway?
I'd be happy to. It's hot and humid. But look, these impeachment sort of petitions have been filed. I think Erwin said there's 7 of them or 9 of them. But nothing's happened with them. And so in that sense, they're, as bad as things are, they could be worse. And there is a sense that I think people understand, and this has actually been a trend over the last couple of years, which is it's cathartic to file impeachment proceedings, but it's really kind of practically impossible to get them done. So most of the sort of impeachment filings, although to me they're a symptom of the problem, I don't think they're really the great threat to judicial independence here. And look, I do think that there are things that Congress can do legitimately. I mean, not everybody may agree with me, but just to take one example, I mean, I think it is beyond obvious that one of the irritants that has caused kind of the friction between and among the branches right now has been the nationwide injunctions. And the Supreme Court obviously sort of had its opinion in the CASA case, and we've already seen sort of the second order class action injunctions and the like. So that issue is going on. That is an issue Congress could address. I mean, if Congress wanted to, it could amend the relevant statutes to either say no nationwide injunctions or only nationwide injunctions in certain circumstances or upon certain heightened filings. I guess the last thing I'll say about this, just in terms of kind of where we are on some of these issues, I mean, my own view is that, what Congress could do to make things better in some respects is to actually do more legislating. Because I think part of the problem that we have right now is, we have a Constitution that's designed to constrain an all-powerful Article 1 congressional branch, the impetuous vortex that Madison talked about. And in reality, we have a Congress that doesn't do much, and then we have an executive branch and a judiciary that seem to be the ones that are sort of solving one way or another some of the most contentious issues of the day. And more things are done by executive order rather than legislation. And that sort of sets the stage for every 4 years. There's a bunch of challenges to the executive orders. There's a bunch of nationwide injunctions or quasi-nationwide injunctions. Because they're nationwide injunctions or close to it, the issues are precipitously brought before the Supreme Court. The Supreme Court gets involved in these contentious issues on its emergency docket. So, in my mind, the thing that Congress could do to best sort of ameliorate this situation is to actually wrestle with some of these controversial issues themselves, pass some laws. Those would be enduring laws that don't change every 4 years. You could obviously challenge them in court, but it'd be a very different dynamic.
So I was going to, before we move to the third bucket, which what can we do? I was going to read a couple of these questions, and then perhaps you can couch your answers in terms of a couple of these questions. So one is, how can the Supreme Court be held accountable for discarding stare decisis other than Congress legislating laws to correct Supreme Court decisions? And two, is the unitary executive theory the underlying basis for the courts permitting interim dismissals that would normally be barred by Humphrey's executor?
I think the second question is easier to answer than the first. And the answer is yes. I think everyone in this room knows in 1935 in Humphrey's executor versus the United States, the Supreme Court said that Congress could create federal agencies and provide that the heads of those agencies moved only for just cause. Humphrey's executor involved the Federal Trade Commission. It was a unanimous decision. Humphrey's executor has never been overruled by the United States Supreme Court. President Trump fired Gwynne Wilcox, a commissioner on the National Labor Relations Board, Kathy Harris, the chair of the Merit System Protection Board, even though they were in terms that were continuing, even though the statutes could provide they could only be fired for just cause. The D.C. Circuit, in a 7-4 en banc ruling, said it had to follow Humphrey's executor, and therefore, since these were individuals who by statute were fired only for cause, they couldn't be removed without such a showing. The Supreme Court in Trump versus Wilcox, 6-3, reversed the D.C. Circuit and said there was substantial likelihood that the Trump administration would prevail on the merits. Just yesterday, there was another 6-3 order of the Supreme Court. This involved removal of commissioners on the Consumer Product Safety Board. And it was, again, the president firing individuals who had protection by statute against removal. And again, it was 6-3, the Supreme Court finding in favor of the president. My criticism here is in part the Supreme Court effectively overruling precedents on the shadow docket. These are cases that came to the court on its emergency docket. If the court's going to overrule a 90-year-old precedent, it should do so after briefing and oral argument, and should do so in an opinion that fully explains the result. In terms of the unitary executive theory, I'd simply say this was a theory that was developed in the early 1980s by lawyers in the Reagan Justice Department. It takes the view that it's a unitary executive that the president is in charge of, so he should be able to fire anyone who works there. It's interesting, the first time the Supreme Court considered it in Morrison versus Olson, the court 7-1 rejected it in an opinion by Chief Justice William Rehnquist. Only Justice Scalia took that view. I think now we have a majority of the justices who accept the unitary executive, which explains the rulings. Just to take it back to our discussion, I think it enhances the judiciary if it writes opinions supporting its conclusions, not when it does this in orders on the shadow docket.
So, I agree that what's going on in these decisions that have allowed these removals to go forward, I think you can only understand that as the court essentially saying that the first factor that we have to consider is the likelihood of success on the merits. And the only way I can explain how that comes out in favor of allowing the removal is that the justices are saying, albeit implicitly, that we're likely to overrule Humphrey's executor. And so actually the executive branch is likely to prevail on the merits in these cases. It's, I kind of thoroughly expected Humphrey's executor to be overruled. I mean, I say that in part as somebody who was appointed by the court to try to defend the removal provisions for the CFPB, and I lost on some grounds that seemed to me to have a distinction of Humphrey's executor, but not one, it was kind of one of those, large railroad distinctions. And so it didn't seem like the kind of thing that would sustain itself over time. So I thoroughly expected Humphrey's executor to be overruled, but I didn't expect it to be sort of signaled so strongly on the emergency docket. So I'll sort of grant you that. But I think it raises kind of a broader sort of issue in trying to understand what's going on with the Supreme Court in particular, which is, as Erwin says, I think you have a Supreme Court, and most of the justices do have a pretty robust view of executive power. And I think some of the things that the current administration is doing probably exceed even that robust view of executive power. But some of them, I think this is a good court to be trying to make sort of strong pro-executive arguments. And I think in that regard, it's fair to criticize kind of where the Supreme Court is on some of these issues if you disagree. I happen to think on some of these issues they're actually probably right as a matter of constitutional theory, but reasonable minds can disagree about that, and we can have a great discussion that can be civil. At the same time, I think people who want to criticize the Supreme Court in terms that really go to its legitimacy and really sort of suggest that the court isn't deciding these issues because it has a strong, robust view of executive power, but is just an illegitimate agency that's trying to facilitate sort of Trump, and you can imagine what some of the rhetoric is about the court these days. And I think that crosses a line as well. And I think I'm so glad that Erwin sort of started with the Chief Justice's report that actually sort of predated the current administration, because I think in thinking about these issues, I always think it's critically important. I've been teaching separation of powers for over 25 years, and I always tell my students, you can't really think about a separation of powers issue clearly until both sides' oxen have been gored. It's all well and good to think the independent counsel statute is a lot of fun when you see the sights trained on your political opponents. But once you see the sights trained on you, you can start to appreciate some of the constitutional problems by having an unaccountable prosecutor. And so I think in thinking about all of these issues, it's really important to sort of, try to take the politics out of it. And I do think some of the criticism of the Supreme Court going back over the last decade that goes beyond criticizing decisions, but really goes to institutional legitimacy, crosses an important line.
Yeah, but isn't it in part what Erwin said, which is that you're making huge changes? I mean, where's the accountability? Where's the reasoned analysis? If that is your view about what they're doing, they're not doing a very good job explaining it, are they?
Well, again, I think it's perfectly legitimate to sort of criticize the way that they're using the emergency docket or the way that they are, handling some of these particular sort of cases. I think that's totally fair game. But to suggest that the way they're managing their emergency docket makes them sort of illegitimate as an institution or the fix is in, I do think that crosses an important line.
But does it weaken the institution by doing it that way?
Honestly, I think sort of time will tell. Which is to say, I think some of these things, it's tough to react in a snapshot, and I think the way that I think the Supreme Court and all of the court system, from the district court up to the Supreme Court, are managing a very difficult dynamic right now, and I'm sure it is frustrating to a district court judge that's trying to do, their level best to address these, situations if they feel like, by the time it gets to the Supreme Court, their relief is being stayed or the case is being redirected to another court. At the same time, I sort of feel like, saying too much right now is a little like predicting an election based on 25% of the returns. I think that, on some of these issues, the court's not saying yes. On some of these issues, the Supreme Court is saying, well, actually, that needs to be filed in this court rather than that court, or we're going to take this issue up, but we're going to save the merits for another day. And I think once you sort of have all the data points, you may have sort of a different situation. But look, I'm not, I think it would be, if there was a written decision that did more to explain why the court's doing what it's doing, vis-a-vis the Humphreys executor issue, I think that would probably be a positive thing for sure.
So let's move to the third bucket, and it adds on to at least one of the questions I have here. So what can we do about this? What should be done to protect the judiciary during these difficult times, especially given the rhetoric by the executive branch?
Let me suggest two things. One is a role of lawyers in bar associations in speaking up for judges individually when they're attacked and speaking up for judicial independence. Obviously, judges are limited in their ability to speak. Their opinions are their expression of their views on the case. But when judges are being attacked, lawyers need to be there to respond, and bar associations need to be there to respond. I think we need to develop, and this includes the academy as well as bar associations, rapid response teams, so that when something is said that's inappropriate, when there's reports of death threats, when there's things that just cross the line, we are ready to go to the press and to go to social media and say that this is inappropriate and why it's inappropriate. There has to be some group of people to speak up for the judges and the judiciary, and I think it has to be the lawyers and it has to be the law professors who do that. Second, we need to do a much better job of civic education in our country. People don't understand the concept of judicial independence. And I worry that it's phrased as judicial independence, it doesn't resonate with people. It's too abstract. I've seen this 40 years ago in California when 3 justices on the California Supreme Court got targeted for their rulings. The defense of them was about judicial independence. Each of those justices overwhelmingly lost the retention election. We saw it here in California, not very far from here, where a Superior Court judge who had an excellent reputation, Aaron Persky, gave a sentence in a sexual assault case that was within what was recommended by the probation office, what was within the statutory appropriate sentence. He then got targeted for that. The attack against him was in large part disinformation. It mischaracterized his ruling. It attributed decisions to him in cases he hadn't even handled. And the defense of him, and I went out and gave a lot of talks, were about judicial independence. He lost with 60% of the voters voting for recall, the first judge to be recalled in California since the 1930s. So I think we need to find a better way of communicating to people about judicial independence. Maybe talking about judicial impartiality will work better, because everyone wants impartial judges. Not sure that everyone understands what independent judges are about. And more generally, we have to find a way for better civic education. If I can, I'll just take a moment about a project that I've been involved in this spring. I had as a co-chair Michael Ludig, the former Federal Court of Appeals judge, and we recruited about 20 people to see if we could draft a set of statements of principle of constitutional democracy. And we recruited notable liberals, Stacey Abrams, Pete Buttigieg, Jamie Raskin, recruited the former Republican governor, Christine Todd Whitman, former Republican Governor Brian Sandoval. We asked Tom Griffith, former D.C. Circuit Judge, known to be conservative, David Tatel, former D.C. Circuit Judge, who's known to be liberal, got Wesley Clark, the former general, to be part of it, notable academics like Harold Koh and Christina Rodriguez, Melissa Murray, Seth Waxman, the former Solicitor General. And our goal was to see, could we as a group come up with a statement of principles of constitutional democracy, no longer than would fit on one page of the New York Times in an ad, but with sufficient specificity to not be platitudes. And a key part of this, which ties today, is about judicial independence. We broke into 5 groups, we came up with principles, we worked them out, and on July 4th, we published them. It was page A7 in the New York Times, published in 5 newspapers, including the San Francisco Chronicles. We called our project, We Hold These Truths. You can find it online. We Hold Truths is the website. And there's going to be a children's book based on it. There's going to be an educational campaign based on it, trying to find a way to show people that the values that unite us are greater than what divide us, that judicial independence is one of those values, and then look for ways to reach people who maybe don't read the op-ed pages, who get their news from social media, to show them that judicial independence and these values are really core to democracy.
Paul?
So I agree with Erwin on this, and what I guess I would say is, a couple of points. One is, I do think the bar has a special responsibility here. And I think in order to discharge that responsibility, the bar also has to sort of, examine its own conscience a little bit, and not fall into certain traps. Because the reason I think the bar has a sort of special responsibility here is because lawyers are also involved in something that's different and hard for people who are looking at everything through a partisan lens to understand, which is we're representing clients. We don't necessarily have to agree with everything that our clients stand for, and some of our most noble and important representations are when we're representing somebody who's politically unpopular. And I think it is important for lawyers to stick up for each other and to stick up for the principles of our adversary system of justice. And I think as a component of that, since the lawyer should understand that you just can't sort of characterize another lawyer based on who their client is, that you can't just assail judges based on the decisions they're making, which may well be just dictated by precedent that they may or may not like, or may well be dictated by sort of facts in the case that the general public just doesn't understand. So I think the lawyers really have to sort of stand up to this, and to really sort of try to vindicate the independence of the judiciary. In briefing some of these cases for the law firms, I came across this line in Justice Kennedy's opinion for the court in a case called Legal Services Corp. Against Velasquez. And he said in essentially these terms that an independent judiciary depends on and needs an independent bar. And I also think that's a two-way street. We can't have an independent judiciary if we don't have an independent bar, and the independent bar has to both stand up for itself and to stand up for the judges and to have the judges' backs, especially when there are kind of more institutionalized attacks on the judges. So I think that's a critical component of it. The only other thing I would say to what Erwin said is, I do like the idea of judicial impartiality. I think it's a better framing. But at some point, I think we have to recognize the difficulty of the challenge we're up against. However you frame it, in a world that's very, very partisan, a defense of neutral principles is just hard to get people excited about. It's almost like you're fighting an unfair fight. People are like going to seize the result, ignore the process, and then just get people riled up about the end result in partisan terms. And so recognizing that that's going to happen, I do think that it's important to try to minimize where it's possible the flashpoints. And let me just identify 2 flashpoints, one of which is an ongoing dialogue. The other one, I think, is just kind of coming into sort of the public consciousness. One is nationwide injunctions and what's going to happen in the wake of the Costa decision. But I think it's just kind of, to me, common sense that a nationwide injunction puts more pressure on the whole system than almost any other order a judge can issue. And that doesn't mean that if they're lawfully available, subject to certain conditions, that you should refrain from issuing one of those. But I think you should recognize that you're sort of, playing with something that's slightly radioactive and explain the decision accordingly. It's kind of a corollary of what Erwin was saying about the shadow docket, where some of the criticism is not fully explaining it. And I think, sort of going the extra mile to explain why an extraordinary remedy is important in a particular situation. It's not going to be a panacea, but I do think it's maybe a necessary kind of responsible step to take to try to turn down the volume if at all possible. And then the second flashpoint, which we're just seeing so far, I think this has mostly been an East Coast phenomenon, but maybe it doesn't stay there. There is this curious provision that gives a district court the ability to appoint a U.S. attorney in certain situations when there's been an interim U.S. attorney, serving for a certain period. That's kind of a weird provision, I got to say. I mean, maybe it's constitutional, maybe it's not. But it puts a lot of pressure on the system when the judges are basically rejecting the executive branch's appointee for U.S. attorney in that district, which is, at the end of the day, maybe my conservative is peeking out here, but that's an executive branch official. That's it's weird to have the judges be in that role, and that's a flashpoint that's going on in the Northern District of New York right now, and in the District of New Jersey. And again, I don't have a solution for that. I'm not criticizing any decision that's been made, but I do think there too, recognize that you're kind of dealing with fire, and you need to. That doesn't mean you don't exercise the powers that you have under a statute, but maybe it does mean that you go the extra mile to explain the dynamic.
If I can just put together what Paul and I was saying briefly, I want to make it as a pitch for personal responsibility for each of us in this room, judges and lawyers. I think all of us have the responsibility to be going into middle schools and high schools and talking to students. Judges as well as lawyers can do this. We have the responsibility of going to Rotary clubs and Lions clubs and all sorts of clubs and talking to them about these values, that this is something that all of us have the ability to be able to communicate to people, and we need to do that. I think it's terrific when courts are able to go into schools, whether it's colleges, law schools, maybe even high schools, and hold proceedings there. So people have the opportunity to see how courts actually work, that judges and lawyers are human beings. I think it's just a way of communicating. And I think we all have a responsibility to think about how we speak. I agree with Paul's phrase from a moment ago, tone down the volume. It is absolutely appropriate to criticize what courts do, but we should also be substantive of our criticism and try to lessen the vitriol that seems to be present now. And this is a responsibility for all of us, I think.
Well, that was the last topic, right? The accountability of judges. It seems to me also that one of the things that there's always been debate about is access to proceedings, and whether our proceedings are offered by video, like they are in many state courts, not so much in federal courts, and audible of all of the proceedings, so that people actually understand how much is going on in the court, and that gives legitimacy to what we're doing. I'm not sure we're going to get through all these questions. We have 12 minutes, and I know I promised you all a couple minutes wrap up for any thoughts you have, but I'll go ahead and read these and see which ones you want to respond to. So for those that the dean or anyone who may have served as a professor, how do you teach constitutional law, immigration, administrative during this time, especially given the lack of attention to stare decisis by the Supreme Court? If a court issues an order and the administration doesn't follow it, what can we do? And can you please talk about the role, well, we just talked about the, can you please talk about the role of the appointment and confirmation processes for Article III judges and the transparency of it? Is this a moment to deal with this kind of issue of judicial legitimacy?
I'll quickly take the first two questions. Paul and I both teach constitutional law. I've been a law professor for 45 years now. I don't think how I teach constitutional law has changed in light of a court that's overruling precedent. The Supreme Court's always at times overruled precedents. I'm always trying to do the same thing in my class. I'm trying to make sure that the students understand the constitutional doctrines, because they're going to be going to state court and federal district court, and they need to know what the law is. I want to teach them to make constitutional arguments, because I think making arguments based on the Constitution is different than statutory arguments or arguments based on common law. And I want them to learn to think critically about what the court says. One of the first things I say to them is, just because the court says it, even unanimously, doesn't mean that it's right. And so none of these things have changed. I've always wanted my students to realize that the decisions of the Supreme Court are now and always have been a function of who's on the court. I tell my students when I have an appellate argument, the first thing I want to know is who's my panel, because we know the identity of the judges matter. None of that has changed. Obviously, the cases have changed. I teach different cases now than I might have 5 years ago in certain areas. There's new principles like the major questions doctrine that didn't exist. But ultimately, it hasn't changed how I teach constitutional law. As to the latter question, it's something that Chief Justice Roberts alluded to in his State of the Judiciary Address and that I mentioned. My greatest fear is what if courts issue orders and this or any president chooses to disobey them. The ability to ensure compliance is limited. As I said, the president can pardon for criminal contempt. It's the United States Marshals and the Justice Department that enforce civil contempt. And if the president, any president, can violate the Constitution and then ignore court orders, then that president can do literally anything. Lock up any of us and disobey court orders for our release. Then we're no longer in a democracy. Then the word for that is a dictatorship. And that's why I think we have to be so very afraid of any suggestion that court orders might be disobeyed.
So I will say, I teach separation of powers in particular, and I do think the way I teach it has changed just a little bit because, for years and years I've had these great hypotheticals, and now some of the hypotheticals have actually happened. So, I'm really kind of straining to come up with, more hypotheticals. And there is a serious point underlying this, and it's something I, sort of teach my students, but I also think it's worth keeping in mind. I think in these situations where there's this real tension between the separation of powers, it causes us to appreciate that, there is the legal limits on the separation of powers, but there are also a lot of norms and understandings that kind of make the separation of powers kind of function as a practical matter. And I think, if you have an administration, and it doesn't matter whether it's Democratic or Republican, but if you have an administration that is, trying to push the limits and is not paying attention to the, the norms and doesn't sort of respect the norms, then I think you're in this period of sort of extraordinary tension. And it does, at least in the separation of powers, it really makes you focus on the limits and makes you kind of, appreciate sometimes the difficulties. I'm somebody who is a big believer in executive power, but I'm also a big believer with the notion that with enormous power comes enormous responsibility, and things like prosecutorial discretion are kind of what allow us to have a system that gives the executive branch a substantial amount of power. There's no two ways about it. Before you get into court, the executive power to decide whether to charge somebody with a felony is about as awesome a power as there is in this country. And, if that power is not exercised responsibly, we're in a real problem because, the 18 U.S.C. has got provisions in it that we can't prosecute everybody for. The system would break down. There's just too many criminal laws. And so the system really at some level depends on prosecutorial discretion, but prosecutorial discretion isn't constitutionally compelled. So I think we are in sort of a unique moment here, and I think it's at least changed the way I teach sort of separation of powers a little bit. On the stare decisis question, I do think this is one of those things that's come up in a couple of questions. I think stare decisis is another one of these issues where you really have to sort of try to think about it through a neutral lens. I think the Supreme Court's proudest moment, at least in the last 100 years, is Brown v. Board, when it overruled one of its precedents. So it can't be that stare decisis is, just to quote the Supreme Court, an inexorable command. And so we can have a good sort of discussion about like what factors, what factors matter, when it's appropriate, when it's inappropriate. As a little plug for the next panel, I spent some time last spring asking the Supreme Court to overrule the Chevron decision. I have no regrets, no apologies. I'm glad they did it. And I'm glad they overruled Chevron and Loper. So I think there are times when it's perfectly appropriate. But we can have a great debate about that. But I worry that sort of, complaining about this court disrespecting stare decisis, to me, that's a little bit of a misdirection. And it's actually more important to focus on the substantive results in the cases.
Okay, so I'm going to give you a minute here as we're wrapping up. But yesterday, most of us were in this room, and we heard Bryan Stevenson, who was fabulous, great speaker, and implored judges to act with courage in light of the fear and anger and the threats. That's the fuel that we need, I think. It's one of the reasons to come to these conferences, to give us the energy to do what we need to do, especially when you have these attacks, and one of our jobs is to protect the individual against the tyranny of the majority, right? I mean, there is a balance. Everybody has individual constitutional rights. So we have examples from the civil rights era, Judge Minor Wisdom, Judge Frank Johnson. As you have your minute, what hope, what encouragement can you give to the judges in this light, in this era, about doing our job under the umbrella of judicial independence?
Although we're speaking at a particularly fraught political moment, everything that we've said today really should be regarded as nonpartisan. Judicial independence is not a partisan concept. Everyone in this room, I hope, whether you think of yourselves as liberal or conservative, should support the notion of judicial independence. And you think about what can we do to preserve it. I think that being a judge now is important, or more important than it's ever been in American history. And I would say the same thing about being a lawyer. I never imagined that I would be as afraid for the future of democracy as I am now. And I truly believe that if the guardrails of democracy are going to hold, it's because judges are there to enforce the Constitution, and that lawyers are there to bring the cases to them. What gives me hope is the resilience of the Constitution over time. There have been other challenges to our constitutional democracy. And when the Constitution has been upheld, democracy has thrived. We can look at countries around the world. There are places where democracies were there and they're no longer there. No democracy lasts forever. But we also can look at places around the world where democracies withstood challenges. And inevitably, the judges were key. When democracies failed and countries became totalitarian, it was because the judges no longer upheld the law. But when democracy succeeded, it's because the judges were there. And so I so echo what Bryan Stevenson said, and I think it's a time where we need judicial courage. We need lawyers to be courageous and stand up for the judges too.
So I agree with all of that, and I do think, just a couple of additional thoughts. I mean, first of all, thank goodness for the framers and the conception of life tenure and putting some structural provisions in from the very beginning that essentially allow judges to be courageous. So I think, and one should never forget that those provisions are in there for a reason, and they do empower judges to do the right thing. They don't have to worry about sort of retention elections. They don't have to, in the modern era, knock on wood, but I don't think, these threats of impeachment are, really real threats. So I think that independence is a great blessing and it needs to be used. I think, both lawyers and judges need to think in terms of what is this going to look like 20 years from now? What am I going to feel proud about the decisions I made, about who I was willing to represent, whether I was willing to challenge actions that I thought were illegal, Or am I going to feel like, in the case of the law firms, I sold out for a couple of dollars on the margin so I could get a third home in the Hamptons? Or am I going to feel like, no, actually, I did exactly the right thing and I stood tall in a moment that was difficult? So, I think the best way to be courageous today is to fast forward 20 years and try to think back about how you feel about sort of your actions in the moment. And I think if you do that, the courage will come, and I do think it will be incredibly valuable in retrospect that people sort of stood tall. The last thing I'll say is just as an anecdote, but I do think it's a challenging enough time that you should always do the right thing in every case. But if there are opportunities at the margin to do things that, as we talked about, tone down the volume, I think it's worth doing those things. In the law firm cases, something great happened. I lost a motion. When I first filed my complaint on behalf of WilmerHale, Chief Judge Howell had already ruled in the Perkins Coie case. So I'm no dope. I want my case assigned to Judge Howell. It's a related case. These executive orders are closely related. So I tried to designate my case as a related case. She rejected that motion. And as a result, the 4 cases were assigned to 4 different judges, 2 appointed by Democratic presidents, 2 appointed by Republican presidents. They all came out the same way. And I think the effect of those rulings was different because it was 4 judges across the spectrum coming to common ground and recognizing that the action was unlawful, as opposed to 1 judge concentrating all the litigation before her and ruling the same way 4 times. So just a practical illustration that in times like this, it's important to be courageous, but it never hurts to be clever.
And join me in thanking these 2 titans.
It's a pleasure.